much for the support that you've given us for the state. I think today is a great day for us as advocate and also as the suspect, and also for the great people of Nyandarua, because the court has really given a very good enunciation of the Constitution and has shown great depth in analyzing the Constitution and the law. And the court has appreciated that the police did not carry any investigation, did not provide any evidence as they brought that application. The upshot of that is that that application, the notice of motion has been disallowed by court, but the court found it fit to give lenient terms. A personal bond of 100,000 is not, it doesn't mean money, because many people may think it's money. No, it's just an agreement that will bind the suspects to be appearing in court, and also to ensure that they also cooperate with the investigating officer in the crime. So it's a great day for us. It's a great win for the Constitution of Kenya. The people of Kenya, when they gave themselves the Constitution, they understood that there could be states and governments that would come and seek to limit their liberties and their rights as guaranteed in the Constitution. This court has shown it is courageous enough, and it has applied the Constitution in the manner in which the people of Kenya, the people of Nyandarua would expect. So we are happy as advocates, and I want to thank all of you for having been very patient. I want to thank the two advocates here who will still make a statement, and the people of Nyandarua for being patient. Today we can celebrate and say that we are free, our people are free at last. Let them carry investigations serious. Let them not bring people who have not perpetrated what they are alleging was perpetrated in this county. We understand very well. The people of this county understand. The people of Olkalou, we know each other. We know each other in Olkalou, and we know the people who actually brought to do the damage that was brought here, so that they could frame certain individuals and certain politicians. That is not something that can be allowed in this country. That is what we are saying, and the courts have come out as the beacons of justice and very, very dependent. So let the state be aware that we are not going to relent in fighting for the rights of our people. That we shall do, and that we are committed to do. Thank you very much.
Having analyzed the matter before me, and for the reasons stated above, I do not find that the police offered good reasons for the continued detention of the arrested persons before me, because the matters they used to justify the detention being suspects of the investigation by taking witness statements, obtaining call data on the applicant's cell phones, analysis of CCTV footage, valuation of the property destroyed being done, are all things that could have been accomplished even with the accused persons or the suspects being out of custody. The upshot of the foregoing is that the instant application for detention is disallowed, and Article 49 offers me 3 options. I will exercise the option of releasing the suspects, that is suspect number 1 to 16, then 18 and 19, on a personal bond of 100,000 Kenya shillings each, plus 2 sureties, who can be contacted anytime, and the sureties shall undertake to produce the suspects as at when required, to which they will commit themselves and be liable to a fine of 100,000 Kenya shillings, or to imprisonment for a period of 6 months, or to both such fine and imprisonment. For the 17th suspect, who is a minor, I direct he be released to the guardian or the parent, who shall execute a personal bond of 100,000 shillings to avail the suspect whenever required by the investigating officer.
The decision by this court today has national implications. The court has been very clear that the police should first of all investigate, gather evidence, prepare a charge sheet before arresting anybody and taking that person in court. This habit of the police arresting a person, then going to court to seek permission to hold that person as they investigate, has been declared unlawful by the court today. This ruling today should actually be circulated to all the police stations and all the police officers, so that they know their work is first of all to investigate before charging, not charging then investigating. That has been annulled by the ruling today. We are also very sad that the police could actually arrest a minor over 16 years, a student, in Form 2, and put him in custody together with adults against the Children's Act law. We are saying, as Nyandarua people, as lawyers, that it is coming out very clearly that the goons that had been hired to come and destroy property and offices in Nyandarua, vehicles and offices in Nyandarua, are from outside. They are not the people that we have seen here who come from Nyandarua. So the police are actually protecting goons, then arresting the innocent protesters and charging them in court. This is something that is not acceptable and is going to lead to a lot of problems in this country. What do I tell the people of Kenya? Kenyans, stand firm. The police and the government might think that they are winning a wicked battle by arresting people and taking them to court, by abducting for a few days. But in the long run, the war is going to be won by the rule of law, by democracy, by Kenyans. The people who are actually committing these illegalities will lose, no doubt. Asanteni sana.
Yeah, thank you very much. From where we left yesterday, and as we said, we have confidence in our courts, we have confidence in our judiciary, and as you can see, the court has done what is expected of a court of law. Application of the law, application of facts and conclusions that speak to the situation that we had today. All the 19 people will be released today. We have sought an order that they be retained at the court cells for a few hours before the lenient conditions are complied with. So for the relatives who are around, you will go home with your relatives. What we are seeing and what I would like to mention is that we've been told several times that the government will not manage politics through the criminal justice system. But what we have dealt with since yesterday and today is a clear demonstration of someone trying to manage politics through the criminal justice system. And the Constitution does not allow that. So I urge all people of Nyandarua, our people of Olkalou, and all the other places within our county to exercise their right fully, because it is only the Constitution and the law that can limit those rights. The right to picket, the right to demonstrate unarmed and non-violently is guaranteed under the Constitution. It is not a donation by the government. It is a right that accrues when somebody is born. So those limitations that the government is trying to bring do not hold any weight. And the court has actually upheld that position. So we are back in court on 21st of July, before which time the investigations ought to have been concluded, and also to be apprised or updated on what is happening. So let's meet again on 21st of July 2025, right here.